coordinator. I've been doing We the People now for over 25 years and have sent many teams from New York here. So I really want to take a deep breath. Okay, you're very well prepared. Don't be nervous. We've got a great group of judges here today. They will introduce themselves in a second. Just to remind you, I will put up a 3-minute sign. Time at 4, 9 minutes. I'll put up a 1-minute sign and then time. You want to put away your follow-up notes once you start your follow-up questions. Good luck to you, and we're Steve back.
Okay, thank you. Well, you're getting at 3, right? That's convenient, so are we. Okay, relax. We're going to have some fun talking about the Constitution today. We'll introduce ourselves, have you introduce yourself and your teacher, and then we'll talk about the selected question for the day. My name is Joe Stewart. I teach political science at Clemson University in South Carolina. Been involved with the We the People program for a number of years, and I've judged here in Washington for quite a long time. I won't say how many, but my hair was a different color when I started. And I always look forward to having these conversations.
I'm Karen Glaw. I'm an attorney at Baker Daniels in Indianapolis. And several years ago, I was doing exactly what you're doing today, and had a great time doing it. So hopefully you guys are enjoying this. It's one of my best memories from high school, for sure. So enjoying the day already, and looking forward to talking with you guys about you.
Good afternoon. My name is State Senator Cisco McSorley. I've been in both the House and the Senate, past chairman of both House and Senate Judiciary Committees, and I've been judging for about 10 years, so welcome.
And he keeps forgetting to tell you he's from New Mexico.
Oh, and I'm from New Mexico.
Please.
Good afternoon. My name is Brittany Blair. We're from Reno High School and from Reno, Nevada. Next year I'll be attending the University of Nevada.
I'm William Pez, and I will also be attending the University of Nevada.
Hi, I'm Ian Mastig, and I'll be attending Cal Poly San Luis Obispo.
I'm Juliana Gordon. I will also be attending Cal Poly San Luis Obispo. Our teacher is Mr. Richard Clark, and our unit coach is Mr. Matthew Oakes, and thank you for being with us today.
We're looking forward to it. Well, this afternoon we're going to talk about question 2. So I will read that question for those who have not spent quite as much time with it as you have. The writ of habeas corpus is the most important single safeguard of personal liberty known to Anglo-American law. Do you agree or disagree with this conclusion reached by a constitutional scholar? Why or why not? Was President Lincoln justified in suspending the writ of habeas corpus during the Civil War? Why or why not? Why has Lincoln's decision to suspend the writ of habeas corpus remained his most controversial policy decision to this day? You may begin.
Thomas Jefferson, in his first inaugural address, said that freedom of the person under the protection of habeas corpus, I deem one of the essential principles of our government. Despite the founders' view of habeas corpus as being one of the most important rights in a democracy, they allowed for its suspension in time of need through Article 1, Section 9, Clause 2. The suspension of habeas corpus limits the majority of due process rights because an individual held indiscriminately by the government cannot even defend those rights in a court of law.
Because the writ of habeas corpus is the foundation for many procedural due process rights, even the suspension of it during rebellion, invasion, or when the public safety is in danger remains controversial. Although the writ of habeas corpus is one of the most important safeguards, we do not agree it is the single most important safeguard, the personal liberty. The writ of it has its root in the Habeas Act of 1679, which established the government must issue the habeas writ unless you are committed by lawful means.
Adopted into the U.S. Constitution through Article 1, Section 9, and used with the Due Process Clause, habeas corpus is also protected by individual states, such as Article 1, Section 5, and Article 6, Section 6 of the Nevada State Constitution, establishing the ability of justices to issue habeas writs. Despite habeas corpus being upheld by both the federal and the state governments, habeas corpus can also be suspended in cases of rebellion or invasion, as seen through the Japanese internment with Executive Order 9066, and later supported by Korematsu v. United States in 1944.
Traditionally, in times of necessities, presidents enact the suspension clause and wait for later legislation to support their actions. Although the suspension of the writ was granted to Congress, as Commander-in-Chief Lincoln was justified in suspending the writ of habeas during the Civil War. Lincoln suspended habeas corpus immediately after the attack on Fort Sumner in 1861, allowing the Union Army to arrest Confederate sympathizers trying to limit Union movement in Baltimore.
Furthermore, the Habeas Corpus Suspension Act of 1863 was not even addressed until December of 1862, thereby proving the necessity of action before the approval of Congress. President Lincoln defended his actions by stating, "I hold that, as a general rule, the commander in the field is the better judge of the necessity in any particular case." President Bush later used this precedent set by Lincoln to suspend habeas corpus for all people considered to be enemy combatants through his narrow interpretation of the Military Commissions Act of 2006.
Because it set the precedent for the president to suspend the writ in times of rebellion and war, Lincoln's suspension of habeas corpus remains highly controversial, especially today, as it is redefined. Throughout the 20th century, the importance of the right of habeas corpus has repeatedly been confirmed by the United States Supreme Court, and has recognized the fact that the writ of habeas corpus is a fundamental instrument for safeguarding individual freedom against arbitrary and lawless state action.
However, in the 1963 case Gideon v. Raynoy, Gideon, despite having the writ of habeas corpus, still did not receive a fair trial because he did not have a lawyer to fully represent him in court. The reverse is also true in the fact that detainees in Guantanamo Bay were detained without a writ of habeas corpus and therefore could not challenge their status as enemy combatants until Hamdi v. Rumsfeld in 2003 and Boumediene v. Bush in 2007.
Justice Anthony Kennedy stated the Detainee Treatment Act of 2005 was not a substitute for the habeas writ, and Military Commissions Act of 2006, Prevention of Enemy Combatants from using habeas corpus to petition the federal government, was unconstitutional. With these new definitions of habeas corpus, the suspension of it in times of rebellion becomes harder for presidents to enact, especially in the face of laws established by the Geneva Convention. Janice Karpinski, a career U.S. Army officer, said in regards to prisoners of war that military police know what to do. They know the Geneva Conventions, and their objective is to provide safe, fair environment for prisoners under their control. Thank you.
Time.
Thank you. So you have the Lincoln quote that says the commander in the field is the better judge. Do you see any dangers there? If we're talking about safeguarding personal liberty?
The dangers certainly arise, especially as we see through President George W. Bush's interpretation of the Military Commissions Act, is that we're seeing how that president feels that because he understands the situation, he can now start interpreting the laws. And so you're seeing more of a retraction of habeas corpus, but because we're not in a state of war, those rights continue to be indefinitely held. When the war ends, those rights usually are retracted by the president.
And furthermore, you can see this danger historically. In World War II, there was a mistrust of Japanese Americans, and this led to their internment. And so just because one group of people doesn't trust the other, a minority group of people, doesn't mean that a general or someone higher up can just say, we should intern these innocent people.
You see the dangers with this, but you also see the benefits of this. With Lincoln, if Lincoln had waited for approval on every single thing he did by Congress, instead of using his commander-in-chief powers, he would have been far behind and far outwitted by the South in many things. We rely on the fact that the president is elected by us and he represents our interests and our issues. And so, while there are dangers, there are also benefits.
Also going off of Will, Abraham Lincoln was in a situation where he had to be the commander-in-chief. He had to keep the country together. He was elected by 40% of the North, and they were his leader. So he was at a commander-in-chief position in order to force the army and force the country to get back together.
So should the Constitution be changed to resolve this question of whether the president has the authority to suspend habeas corpus? It sounds like you support the president being able to do that. Constitution's not super clear. Should we amend the Constitution to make that more clear?
Because it's already in the Constitution through Article 1, despite it being more of a legislative article, it shouldn't have to be rewritten, especially since we see that the president's actions have changed over time. It doesn't need to actually be in the Constitution. It's still flexible.
If you just tie down certain parts of the Constitution by expressly labeling them as one part or another, it almost ties down the necessity of government in a way that government, a lot of the things are flexible. You see this with the Second Amendment, with how it can be loose interpreted as individual or collective. You can also see the interpretation of the Constitution being necessary to a certain time or certain situations.
I do think an amendment is a good course of action because the president now can be seen as above the law, especially in Guantanamo Bay where people are labeled as enemy combatants. and the court cases Hamdi v. Rumsfeld and Moonbeam v. Bush show that there's a need for more protection of the rights of enemy combatants. Though some of them are U.S. citizens, they're still not getting their fair say in court.
So, if you do or don't think the Constitution should be changed, could you directly address the idea of what position Congress should or might not have or shouldn't have in relation to habeas corpus and the suspension of habeas corpus?
I definitely think Congress should have a say in habeas corpus due to the fact that they do represent our people, that they do represent the people who will be getting habeas corpus taken away from them by expressing their freedom of speech, freedom of assembly through rebellion or such. This is the fact that Congress is there to protect us.
Furthermore, instead of creating their own definition of habeas corpus, Congress should actually look to the international definition of habeas corpus, such as the International Covenant on Civil and Political Rights. They actually define habeas corpus themselves. So Congress should have more acts looking towards the international standard for habeas corpus.
I'd like to disagree with my colleagues because I don't think Congress should have a role to play in habeas corpus. I think it should be left up to the president, and because he's in charge of the military in times of war. So he should be able to have the flexibility that a direct democracy or answering to already divided and gridlocked Congress wouldn't allow him to have.
If we have time, I want to come back to that, but before we do, I believe you argued that habeas is not the most important safeguard of personal liberty. If it's not, what is? What ranks ahead of it?
Due process as a whole, I believe, is the most important safeguard. That we should not be pinpointing one certain safeguard of due process because it's always changing. As you see in Miranda v. Arizona, we would not be having our ability to have our Miranda rights read to us when we are taken in. So as you see that due process is our most important in a safeguard for people.
Unanimity on that?
I was interested in the last quote in your opening. Did you? Yeah. There's so much to talk about. I was interested in that last quote in your opening and how that plays into your analysis. The quote about from an Army officer talking about the how does that play into how you guys think about habeas?
It definitely plays into the fact that there are definitions, especially we see as, because our enemy combatants are not technically covered under the Geneva Convention. The Geneva Convention covered civilians, and so it really does leave a little ambiguity for what the officers themselves do. So if the officers themselves take it upon it to follow the Geneva Convention, you see more of habeas corpus rights actually being protected instead of hurting these combatants because they're not always trying.
So getting back to this question about congressional.
Time.
Never mind.
Never mind.
We'll get back to that.
Well, I'm of course shocked that we didn't resolve all these questions. But no, I thought you did a very good job of presenting kind of the wide-ranging issues here, going from Thomas Jefferson, and I thought you did a very good job of presenting some clear positions, really laying out some interesting things that I do wish we had more time to talk about. Good connection to Gideon, which laid the groundwork for your position about connections to due process in general, and some intriguing ideas drawing on international definitions of where we should be looking. My suspicion is that the people who get apoplectic when we start citing international cases would probably be apoplectic about citing international definitions of habeas corpus too. But all in all, I thought just a very enjoyable, wide-ranging discussion. Well done.
I agree. I really enjoyed your opening. It's hard in 4 minutes to answer questions, get in a lot of examples, get into history, and get in the kind of philosophy and background, and you did that very nicely. You can tell that you worked very hard to put the right things in there and strike the right balance between all of those. I enjoyed the follow-up. I think the goal on follow-up is to get a lot of questions asked and answered, and to have a conversation, and to leave us wanting to talk to you more, and you absolutely did that. and to leave you wanting to talk about more too. And hopefully you ended that way too. Again, 6 minutes is a really short period of time, so we covered a lot of ground in 6 minutes and could cover a lot more. That shows that you really know a lot about this topic, which is obviously a good thing. You had good excitement and good energy and follow-up too, which I know is not anything we're really judging on, but that shows to me that you're interested in what you're talking about. And it also shows that you spend a lot of time doing research and thinking about this and talking to each other and talking to your teacher in your class about it, which is fantastic. I liked that on a lot of the questions you were showing us both sides, that you disagreed with each other, that you could explain both sides of the issue, which is very nice. I would caution, since you guys know so much information and you're going to get a lot, your rounds are going to be like this, don't think that you all have to answer every question. Because there was a couple times where it was a little repetitive right at the end. You don't all have to get on to everyone. You're all going to talk plenty during follow-up. You all know this stuff. So if your colleagues have covered it, don't feel like you have to get in on that one and give us a chance to ask another question if you have time to. But that aside, follow-up was great. Wish we had more time.
At the unusual situation of being called a ditto head for the first time in my life, I'd like to agree with exactly what my colleagues are saying. Your history was wonderful. The idea that you brought it back to the Nevada Constitution emphasized that it's so important, even your state has acknowledged it. Your ability to discuss congressional action versus presidential action and the Congress representing the very people that could be put away, that was wonderful. Your reliance on international. And then when you wanted to discuss due process, you went right to the heart of Miranda, and it was very strong to be able to say, wait a minute, there's a big picture here that I can see, and all I need is another 6 hours, and I know you'll be able to see it too, but you were really good, and your energy was wonderful on it, so congratulations.